I'd like to introduce our presenters for today. We have James Gempler and Jen Riza from the North Star Law Group, and rather than belabor that, I will just turn it over to them.
Well, thanks so much, Sarah. I'm really excited to be here. Yes, I'm Jen Riza, and I am the head of business and cannabis at North Star Law Group. And I'm really pleased to be here with my partner, James.
Hello. Pleasure to be here. I'm the head of criminal defense and expungements here at North Star Law Group, and excited to present here today.
Awesome. So really glad that you all are here today. Excited to hear what kind of questions that you have about cannabis. Here's our plan for today. We're going to start by talking about the changes to criminal law. Of course, HF 100, the Omnibus Cannabis Bill, passed this spring. Lots and lots of changes that roll out over time. So we'll start with the criminal law changes. We'll talk about expungement of past cannabis convictions, both automatic and non-automatic. Those are things that James is expert in, and so he's going to start us off with that. Then we'll turn it on over to me. I'll talk about the licensing regime that HF 100 created for businesses that want to sell in the cannabis space. And we'll talk about regulation of the already legal hemp-derived beverages, which you may well have seen in liquor stores and grocery stores already. And then we hope to leave lots of time for questions, because we're excited to hear what you guys want to know about and do our best to answer that. So without further ado, let me turn it over to you, James.
Sounds good. All right. So as Ms. Riza just explained, what we're here basically talking today about is the changes in the law relating to the legalization of cannabis. And the most immediate effect, it has to do with adult use, possession, and then home growth. Those laws are in effect as we speak. Now, that doesn't affect sales. That is coming down the road, and Ms. Riza will be talking a little bit more about that and what that means and how to go about it. But what I'm going to talk about is the legality and the criminal nature of adult use, possession, and home growth. So we'll go from there. Can we go to the next slide? All right, so let's talk about what's legal. It is legal to possess marijuana. When or how much you possess and where will determine the amount you can actually possess. To begin with, paraphernalia is legal to possess. And then when you're in the general public, 2 ounces of cannabis flower is lawful. When you're at home, that rises to 2 pounds. And then we got different forms of cannabis and the concentrate edibles infused with THC. There's different amounts there as well. The thing to note too is that if you are in public, you can share the cannabis so long as it's under the legal amount that you can possess. So those are the what's permitted for possession. And then let's talk about the use. You can use cannabis legally anywhere at your private residence, including the yard. Then if it's at other private property, you can use it if it's not otherwise prohibited by some sort of local ordinance or the policy of the owner. So apartment complexes, you kind of have to figure out what's lawful there based upon the landlord's discretion or policies or whatever else may be in place. And then if you're going to like a bar, if it's an outdoor patio, some bars might permit it, some might not. It depends on the city, things like that. And then as well, we're looking at public outdoor consumption. Again, it's permitted, but you have to be careful about where you are. Some local municipalities and jurisdictions will prohibit it, such as use on the sidewalks or in parks, things like that. So you got to make sure you're aware of where you are and what the local rules and laws permit. So that's where you can use it. Obviously, it's a lot of obligation on the user to understand what the local laws permit. So now we understand before what's lawful to possess and use. So what happens when you go a little bit too far? Well, as you can see, there is a separate criminal statute specific for cannabis offenses. Previously, cannabis offenses were looped in with the other controlled substance crimes. Now, with legalization of cannabis, they have taken it out and basically created a whole new separate area of crimes specific for criminal possession of marijuana or cannabis. And as you can see here, the possession laws will go from first-degree felony all the way to a petty misdemeanor, fourth degree. Where you fall in the range of crimes depends on how much you have and where. If you have, for instance, if you have just over the legal amount of cannabis flower in public, you got like 4 ounces, that's a petty misdemeanor. If you're carrying around a couple pounds, well, then that's a felony. And obviously you can have less than a couple pounds, but if you're in public, that's a crime too. It depends again on where you are and how much. And as you can see with cannabis concentrate, THC edibles, excuse me, it all depends on how much and where you're located for felony all the way to petty misdemeanor. What's interesting to me is the legal use in public. So if you are improperly using marijuana or cannabis and you're out in public, that is not a crime. It's a petty misdemeanor, which by law is not a crime. So it's a deterrent, but how much is really, I don't know, I'm curious to see. Because petty misdemeanors will, in theory, should not show up on true criminal background checks, though the record exists. So obviously people still want to probably avoid it, but bottom line is it is technically not a crime. So I'm not sure how much that might deter certain, some individuals. So it'll be interesting to see if that's insufficient enough of a deterrent for some municipalities or the state, and if they determine it's not, to see if it gets changed to make it a more serious crime. Otherwise, transportation. First of all, it is a misdemeanor. It's a crime if you use cannabis in the motor vehicle, even if it's just parked. So just understand, if you're in a motor vehicle, you're at like a public, you're just parked on the side of the street, you're parked at a park. I'm gonna try to figure out how many ways I can say park here, but it will depend on, it's just a misdemeanor. So even if the person's not driving, it's a crime. And then when you have cannabis in your vehicle, it's just like bringing home a six-pack of beer. It's got to be in the original packaging. It cannot be open. It cannot be, partially used, things like that. If you have it in the vehicle, it must be kept in the form in which you legally possessed it. So keep that in mind. So we talked about legal use and legal possession and the crimes associated. There is a third way to have legal, that's legal now for cannabis usage, and that is home cultivation. So you can grow your own cannabis for your own, for your use. So there is a separate statute in play that talks about this. And what the rules permit is up to 8 total cannabis plants with a maximum of 4 being mature and flowering. And that the cultivation, the growing process, must be in an enclosed, locked space, not open to the public. So what's going to be really interesting and lead to a lot of litigation is how they go about trying to define cannabis plants and mature flowering plants. I am far from an expert in this area, but my understanding is how you deem one plant to be mature and or flowering could be debatable. And how you deem one being technically a plant. I mean, obviously we're lawyers, so we're just going to muddy this up as much as we can. So it is going to be interesting to see the enforcement mechanism of this and how it leads to, I'm sure, some litigation about at what stage of the flowering process or maturation process it is to be considered outside the rules of what's permitted. So if you do go outside the rules, there's crimes, of course. First degree felony if you have 24 plus cannabis plants, then it's a gross misdemeanor if you have 17 to 23 plants, which leaves a gap, 8 to 16. Not a crime, apparently, but something to keep in mind, there are civil penalties in play. So if you have more cannabis plants than permitted, but less than the crime, you can, well, excuse me, let me back up. If you have a plant over the 8 permitted, it's a $500 civil penalty per plant. So will that deter enough people? I don't know. But the point is that there is a penalty if you have like 10 plants, let's say, of $1,000. Next. So now that the state has made cannabis legal, they are, to their credit, they're trying to retroactively address cannabis-related crimes in the past. And they're doing that through 3 different mechanisms. First, there is an automatic expungement of certain cannabis convictions. So what's going to happen is the BCA is going to take a look at some records and make a determination if a certain criminal record is eligible for an automatic expungement. So the type of records that are eligible are listed, as you can see. Basically, discharge and dismissal pursuant to 152.18. For those that aren't familiar with that, basically that is a first-time drug offense in which a person possessed a illegal amount of cannabis, but not a ton. So therefore, on first-time offenses, it was presumed to get what's called a statutory stay of adjudication. It's a 152.18. It's automatically granted. It is an admission to guilt, but no conviction. The person does well on probation, then the admission of guilt is thrown out and the case is dismissed. So those type of records will be eligible for an automatic expungement. The others are those that are resolved in favor, like an acquittal or continuance for dismissal, those that are dismissed prior to probable cause finding. And then we're talking about misdemeanor levels of possession of motor vehicle and a small amount of marijuana possession, which was a petty misdemeanor. Those are any prior offenses, convictions of those are automatically expunged. So what does that mean? Well, the BCA identifies a record, makes a determination it should be automatically expunged. So they seal their records, let the court know, and the court is supposed to issue an order granting the expungement and then sending that order out to the appropriate parties. What's good to know is that the individual this applies to, they do not have to file a request for this. They don't have to take any action. They're just supposed to rely upon the BCA and the courts to take care of it. What is going to be problematic, I think, is these records or these expungements do not automatically expunge any records held by the Department of Human Services or Department of Health. And the DHS in particular has a long list of offenses that can be disqualifying for professional licenses. That is often a major driving force for individuals trying to get an expungement. So if an individual gets an order saying, hey, your record's been expunged automatically, they may need to understand that, well, I need something else. I need something more than this because I have DHS records that are in play. If that's the case, presumably that person is going to have to actually file a petition with the court and seek a full expungement under the standard statutory process. So if a offense does not qualify for an automatic expungement, it still could qualify for an expungement or resentencing as determined by a cannabis expungement board. This is where things get a little more messy. So for those cannabis specific offenses that aren't eligible for an automatic, what will happen is BCA will identify these records and then send them to the cannabis expungement board. And then the board will make a determination what should happen with these records. So let's talk about what the board is comprised of. It is comprised of a chief justice, or an agent thereof, AG, agent thereof, public defender, agent, community corrections, personnel, and then a public member. By law, the public member is supposed to have some sort of understanding or appreciation of the law in play. So it's not completely random, but there's gonna be some randomness to it. And then what the board does is they review the records to determine if the cannabis record in play is now a less serious offense under the new law, or simply might be not illegal anymore. And then they determine if the conviction should be vacated, dismissed, expunged, or if the matter should just be resentenced to what is now the less serious offense. At the same time, which I think is very smart of them, will make a separate determination too if gun rights should be restored. Because currently, or previous to this, controlled substance crimes are deemed crimes of violence, which results in the loss of gun rights under state law. So if cannabis law changes and the prior violent crime is now a lesser offense, then the gun rights might be appropriate to have restored. So what crimes are we considering? Anything related to cannabis, first degree, sale, all the way to fifth degree, felony, sale, possession type crimes, but they cannot involve a weapon or a physical violence assault. The record would now be a less serious offense or no offense at all. And then the appeals process and things like that have kind of lapsed. If those records fall into that category of offenses, then the BCA will figure that out and send it to the board. And this is where it gets kind of messy, because I truly am at a loss here for how this is going to really play out to have the meaningful impact that I think the legislature desired here. Because as of now, the board is scheduled to meet at least once a month. It's going to be open to public. And then the board is required to review all the records. This isn't some surface level review in theory. They are supposed to look at a number of factors to make a determination as to what the appropriate outcome is. Those factors include the severity of the crime, if there's any victim input, how they go about trying to get victim input, if everything's done by the BCA, I don't know. They make an assessment of public safety risk by the record holder, if the person is incarcerated or not, any aggravating mitigating factors, level of participation, planning, all sorts of things. That if those are the factors, it's going to require some sort of a relative deep dive into the records. So that's why the board has a subpoena power. So they can, in fact, subpoena records from the local agencies to try to get the records necessary to do the review. Well, that's going to take time. And then my question too is, who's doing the subpoenaing? I mean, are they going to have staff that's going to help them with this? How do they organize everything? How do they make sure they get everything? And for older records, for older convictions, do we still even have those records? And if so, I mean, there's a lot of questions in my mind about how easily this is going to be taking place. And then the other question is, if you're meeting once a month, let's say, is there an expectation and requirement that the board do some prep work ahead of the meeting so that they can be ready to discuss the cases? If that's the case, that's going to require a lot of prep work, especially if they're going to be reviewing the cases in some level of depth. So that's going to require a lot of work for the board. And truth be told, they're not getting paid a lot. So how motivated are they going to be to do so much work outside of the monthly meeting? And if we have one monthly meeting, let's say 7 hours of actual work time through a day, how many records do we get through? I mean, are you talking a couple an hour, several an hour? I mean, you're still looking at 15 to 40 to 50 if we're getting extremely aggressive with it. No doubt that's meaningful for those individuals, but I think we'd all generally agree that there are a lot of records out there. So, I mean, you're making progress, but it's going to take a while if we're doing it once a month and have to do such a level of depth of detail. So, it's going to be interesting to see how this plays out. And then the other thing too is once the board meets and they make a decision, what they need 3 of the board members to vote affirmatively for the course of action. Once 3 board members say yay, then that course of action can take place. And like I said, the options are an expungement. So that means the vacation, dismissal of the record, and then an ultimate expungement granted. If that's not on the table, or if they deem like, no, it's still a pretty serious crime, we're going to lower it, we can resentence it. So then they can do a resentencing process, which means they could do it automatically, administratively, or they can request a hearing, which raises another headache, I would imagine, for all sorts of administrative reasons, but that's what we're dealing with. The other question I have is, if a person is ultimately denied either option, do they get notice? Because if there is an expungement order or a resentence, in theory, the court should be sending some sort of order and notice to the individual, saying like, hey, record's been expunged via this process. Well, if the board makes a review and says, nope, not going to happen, obviously that person still has an opportunity, I would think, to challenge it or to bring in their own bring their own expungement effort. Will they get noticed? Will there be even a record put in MCRO saying, hey, there was the expungement board reviewed it, made a decision? No, I honestly, I don't know the answer to this. So it's gonna be interesting to see. Part of me says they're gonna have to make some sort of change to have this board meet more, or make it a meaningful job with meaningful pay to really make an impact with this. Because otherwise, a couple handfuls of records here and there every month, while great for those, is hardly going to make a dent in the grand scheme of things, I think. So we'll see.
Thanks, James. Appreciate it. I see that we've gotten a couple of questions about James's half of the presentation. James, you want to just hit those quick before we switch over to talking about business licensing? I can take the first one, which is the 8 plant limit is a per household limit, which is a little confusing because the possession limits are per person, but the home grow is per home.
And then as far as the DWI laws, the open container, I'm drawing a blank on the proper name, but regardless, curious. Open package law, I knew it was something like that. That is under the that is under the DWI 169 chapter 169A chapter. Now, DUI laws still are in play, because if someone lawfully uses cannabis prior to driving and then gets behind the wheel, they can be impaired, of course, in which case it would be a violation of the DWI laws. The problem is trying to prove it. Now, I'm a defense attorney, so I don't want to give away all the secrets, but they have to try to go about proving it. The mere presence of THC in someone's system, found via a blood search warrant that gets a blood draw, the mere presence of THC in the system is not enough to prove an impairment. And the BCA has testified to this in the trial I had. And the reason why is the sheer amount of THC found in the system does not correlate to actual impairment. So to explain this in maybe simpler terms, if you drink alcohol, if you test above a 0.08, you are by law impaired. There is no 0.08 threshold that you surpass in THC levels to be deemed automatically impaired. Part of the reason is everyone's metabolism is different, how they ingest the THC, through what mechanism, and THC can be in your system for days. So if someone ingested THC 2 days ago, and then they get pulled over and have a search warrant done and blood draw, that THC that was ingested 2 days ago would still show up. So what that means then is they have to go about trying to prove it through different testing that is specifically designed to determine impairment caused by drugs. And there is a category of drugs in that testing specifically for cannabis. So the officers need to be trained, and there was a part of this new law included a significant amount of money being devoted to law enforcement to make sure that the officers are getting the required training to determine impairment. Statute of possession of firearm after. I honestly don't know. That's a good question. But for the automatic, if we're talking about the expungement, you'll see that the eligible offenses did not involve a weapon or assault. So for that, you want to be eligible for an expungement. Don't know. I can definitely go take a gander here. I don't remember that one offhand.
All right. Well, if you don't want to listen to my presentation about business licensing once again, you could go check it out. All right. So as we said, I am the business lawyer, and I am super excited to be a business lawyer who primarily represents cannabis, small businesses and entrepreneurs while here at North Star Law Group. So let's talk about how HF 100 creates a regulatory system. Minnesota was the 23rd state to legalize what we call adult use or recreational use of marijuana. And so obviously there are a lot of decisions that were made by the legislature to try to learn from the mistakes that had been made in other jurisdictions, and to try to create a bill that was fair and complete. So here's where they landed. First, we're going to be a merit application licensing state. Some states held lotteries for licenses, or did other kind of blended approaches? Minnesota is going to be a merit application state. People are going to have to submit, significant applications speaking to their future business, and some lucky people at the Office of Cannabis Management are going to have to get to read all those applications and try to figure out who rises to the top. Minnesota's goal was to create a craft industry, thinking of the amazing craft brewing and craft distilling industries that we've cultivated in recent years. Minnesota barred vertical integration except for small businesses. What that means is that the big out-of-state cannabis companies, because there are huge companies in California, Colorado, and Canada now, if they want to come into Minnesota, they're supposed to have to choose. Are they going to grow? Are they going to manufacture? Or are they going to be on the retail side? I mean, they can't hold licenses to do all three of those things at the same time. In addition, though, Minnesota created a small license category called a micro license, where you can be fully integrated, but just have one retail shop. So you can grow, manufacture, sell, and actually serve for on-site consumption all in that one little place, as if it was something like a destination distillery or brewery, right? So that's the micro license. There's also a mezzo license, which allows up to 3 locations. That's pretty unique as amongst the states. And I'm super excited to see what our micro licensees are going to be able to do. In addition, trying to learn from the mistakes that had been made in other states, a compromise was reached that municipalities can limit the number of cannabis dispensaries within their county or state, but they can't ban them entirely. One of the things that had happened in Colorado when they first legalized was they allowed counties to decide to be essentially dry counties for, dry from cannabis. And that created a weird patchwork where Denver has, approximately 1 billion dispensaries, and people in the rest of Colorado don't have very good access to, quality regulated licensed cannabis, and it allowed the black market to thrive in those communities as well. So the policy decision here was that everyone in Minnesota deserves access to quality licensed cannabis, and we're trying again to bring the black market into the light and to replace it with a regulated scheme. And so municipalities can limit the number of dispensaries within their territory, and it's based on a certain formulation based on population, but they can't ban them entirely. So HF 100 also creates a brand new government agency called the Office of Cannabis Management, OCM. They are getting started. We may have seen that the governor tried to appoint a director, and that director was not well vetted and resigned, which was unfortunate. But there are other good folks working hard to get the OCM set up, even in the absence of a director, and start to promulgate rules. They have put out a survey where they're asking for input from the public about the rules that they should create, and they are getting started. We do anticipate that they will spend at least the next year working on rulemaking and promulgating the forms of application before people are going to actually be able to apply for those applications, which means that dispensaries won't open until possibly late spring 2025, or possibly even a little later. So we're in this weird time right now where possession is legal, but no one is allowed to sell marijuana unless and until they are a licensed retailer, with 2 exceptions. One is that the tribes, of course, are allowed to establish their own licensing requirements and open shops for sale at any time after August 1st. And in fact, 3 tribes have announced that they are taking advantage of that and have established those rules and have opened to the public and up north. And so there are legal sales of cannabis happening at Red Lake and White Earth reservations up in northern Minnesota. And I think Leech Lake is planning to open soon. There's also an exception in the bill for gifts. And the exception basically says an individual can possess 2 ounces. They can also give 2 ounces of flower to others for no remuneration. And so I am warning my clients that really means you can't barter, you can't, do any of this selling, an expensive t-shirt that also includes a joint that we saw in some other states. The Minnesota legislature was specifically looking to close that door. And so we should be careful about gifts. They really did mean true gifts. So those are the things that, we're working through right now. I'm helping a lot of people figure out which of the 16 license categories they potentially want to stand up a business in, helping them work on their license plans, and excited to start the rulemaking process with OCM. Hope to help them as well. But you may have noticed that there are products with THC being sold in Minnesota right now. And these are what we call the hemp-derived THC products. Let me take a minute and give you an unexpected botany lesson, if I could, because I know James and I have been using the terms cannabis, marijuana, hemp, and it's a little confusing. So let me see if I can give you a better explanation of all of that may help this make more sense. So the plant itself is called Cannabis sativa. That's its Latin name, right? And like any plant, I grow heirloom tomatoes, for instance. Okay, like any plant, it has various varietals. And those different varietals are going to have different, amounts of THC or whatever else happens in the plant. Okay, so there is a varietal of the Cannabis sativa plant that we call hemp that has a very low amount of THC. And so the 2018 US Farm Bill said it is okay to grow that hemp varietal, defined as less than 0.3% THC by weight of the flower when it's grown. And the 2018 US Farm Bill did that because it has uses as industrial hemp to make rope and other kinds of, hemp products. Okay. But it also opened the door for what is now the hemp-derived industry, because CBD is generally derived from hemp, and that's how it can be sold nationally and across state lines. And CBD can also be converted into hemp-derived THC. And as long as you've started with that hemp product, then it is still considered to be hemp-derived. So Minnesota has taken the lead in trying to regulate and take a thoughtful and cautious view about these hemp-derived products. And in 2022, Minnesota statute clarified that beverages and edibles that included less than 5 milligrams of hemp-derived THC per serving could be legally sold in Minnesota. So that created a huge business opportunity that breweries and distilleries and other entrepreneurs have jumped on to create beverages and edibles that comply with Minnesota's law. In addition, the HF 100 2023 Omnibus Cannabis Bill added important regulation to this market. It added additional taxes of 10% on these products. It added a specific licensing regime, which is starting to be rolled out, as well as testing requirements to make sure that all of these products, which are legal to sell, are also safe to consume. So whatever you call them, hemp-derived THC, you may hear Delta-9 or edible cannabinoid products. That is that whole range of beverages and edibles, which are now legal to sell. And we are seeing Minnesota become a national and even international leader in this market, because Minnesota companies can sell these products across state lines, for instance, into Wisconsin and Texas, states that are unlikely to have full recreational use anytime soon. And I expect that some of my clients will actually stay in the hemp-derived space and continue to run businesses in that space, rather than looking to switch to the full cannabis space once it's legal, because of the lower barrier to entry and the national distribution. So anyway, I will move on, but happy to answer more questions about that. Okay, so to sum up, as of today, November 15th, 2023, because it does change, so don't hold me to this anytime after right now. What's legal is possession of small amounts, right? 2 ounces of flower, equivalent small amounts of edibles or other forms. Home grow within those limits, 8 plants, 4 flowering at a time. And the purchase and sale of hemp-derived products is legal. What's not legal? Obviously, possession in excess of the limits. And as James noted, that often has to do with what kind of space you are in as well. Use in the car, possession of the car within the reach of the driver is something that individuals should be careful about. And sales are not legal, except, of course, for the tribes. And then finally, marijuana remains illegal under federal law, which has important implications as to airports and other interstate activity, immigration questions, federal jobs, and then causes real headaches for the legal cannabis industry in banking, intellectual property, taxes, etc. Happy to talk about about those in more detail with folks as well. All right, so let's start our Q&A, and I do see that I have one question that came in, a great question that I get all the time, which is there a cap on the number of licensed businesses? And it's a great question because some states indeed did set their regime and say, this is how many of these businesses we want. A couple of them said, we only want a few large vertically integrated cannabis businesses. Minnesota has taken the opposite approach to that, said, we want many players in a large, not vertically integrated industry. And they did not set any numerical caps, instead instructing OCM to study the question and figure out, what kind of market and what kind of amount of licenses would be reasonable. And so it will be interesting to see where OCM lands on that, and if they tell us that or not. I don't know at this point. All right, what other questions do you guys have for us?
Perhaps I can maybe go back to this question. I don't have a full answer for it. The question is, how does the change in legalizing cannabis affect unlawful possession of a firearm? Like I said, there was previously, felony drug crimes are considered crimes of violence, which means you lose your gun rights. If you get caught with the possession of a firearm, then it's another crime. The statute that was provided, there is new language, or there's language in there now that talks about lawful use of cannabis, basically lawful use of cannabis would not mean illegal use of controlled substances. So there is some sort of language in there that talks about, that kind of incorporates the legality of using it now, so long as it's obviously done lawfully. But what's going to be interesting to me is, the old offenses, the old offenses are going to subject to expungement and or resentencing if and when that happens. If someone gets caught having not had their conviction rectified or resentenced, should I say, like, how does that impact things? I honestly don't know the answer to that. So I have a partial answer only, sorry. Let me see here. Yeah, essentially there is, so the question basically is, if you can't prove impairment by the blood results, how do you prove impairment? And the answer is through the behavior, the driving conduct, and how the person is acting. So versus, the basis of the stop. How is a driver driving? If the person's all over the road, that looks like the person is impaired. Once they talk to them, do they smell an odor of marijuana? Do they have pinpoint pupils, or do they have do they exhibit indicators of impairment with their talking, their mannerisms, things like that? And then there is a set of field sobriety tests that is designed to determine if a person is impaired by a controlled substance, and it can also point the officer into determining that the person is impaired by a specific set of substance. So it's called a drug DRE, a drug recognition evaluation, and the person that conducts it must be specifically trained in conducting it. This is above and beyond just getting field sobriety test training. So right now, every DWI cop does standard training and then field sobriety training. If they want to do this drug recognition evaluation, they have to do what's called an A-RIDE, test or training, and then specific drug recognition evaluation training. So there's two more steps, and they are lengthy training. But like I said, the idea is once they have that training, they'll run the individual through a bunch of those tests, and then should, in theory, be able to say, based upon their performance, they are impaired.
Thanks, James. I got a couple of questions about the interplay between federal and state law. Simone asks specifically, at one point, the FDA had a stake in marijuana and hemp activities, so the FDA still have a role. They certainly do. One thing that's happened relatively recently is that the Biden administration had asked the federal agencies to go through the process of looking at formally looking at whether marijuana should be descheduled from a Schedule 1 drug to a Schedule 3 drug, or descheduled, I guess. And the FDA, in fact, is expected to recommend that it be descheduled to Schedule 3, which is the schedule that like Tylenol 3 and ketamine are on. So substances that, need prescriptions, kind of is sort of what it is. And then the FDA is also concerned in protecting consumer products. We've got, for instance, CBD salves and things like that. And so there are certain warnings that we have to give that, just like vitamins or other kind of non-FDA regulated things, this has not been evaluated and you can't make certain health claims. So those are the FDA's main roles at this time. Definitely a developing area as we move forward.
So there was a question about following up. If the officer does not have that specialized training, then what? Then the state's going to have a hard time proving the case. I actually had a DUI cannabis related trial last April, and no DRE was conducted. The driving conduct was nothing special. My client's behavior was otherwise nothing special. And as you can probably imagine, without the DRE, I was able to point to a large gap in the state's proof of being able to prove beyond a reasonable doubt. And the jury agreed within, they were out for like 45 minutes only. So, without that specialized training, they really are kind of hamstrung and be able to prove actual impairment, which is what's required.
James, you indicated that in theory, DRE serves to demonstrate whether an individual is under the influence of THC. Do you have a personal opinion about how compelling that evidence is as a practical matter? There's a number of us, I think, that at points think it's utterly subjective, gives rise to potential for abuse, and is simply not anything equivalent to a breathalyzer in the context of DWI alcohol consumption case.
Correct. Without going too far in my answer here. There's always abuse. Let's be honest. But that's where, you have to get the reports. And then obviously this is where body camera and squad video and things like that will come into play to really show if these allegations of failing certain tests and things like that don't match up. Obviously that's going to make a difference in the state's ability to prove the case. And even if there's some technical violations, but overall the person isn't exhibiting it outwardly, there might be difficulties in the state's case. But that's what you're going to see then. It's more trials, I would imagine. Typically getting it dismissed prior to is going to be pretty challenging, but at trial, having the ability to prove the case based on, as you said, truly subjective tests, they're going to try to, talk about all their based upon their training and experience answers, but that's where we can come and cross-examine them and kind of show out where maybe there's some shortcomings.
Well, just to be a little bit more pointed, and if you don't want to go there, I totally understand, but do you recognize as sound science DRE in theory or not?
Well, I mean, that's a whole nother, like, going down the deep end, not deep end, I should say, excuse me. That is an area where, certainly depending on the client, their bandwidth to get individuals involved to testify about just, how reliable these examinations are, certainly is an area that could be explored. Because, even the quote unquote gold standard of the field sobriety test only have success rate in the 70s, I think. So I honestly don't know offhand the similar stats as it relates to DRE, but I gotta imagine it's going to be not too far off from that. So I think overall, I can definitely point to that.
No, I appreciate it. And again, I'm certainly not interested in putting you on the spot. I am more than interested to hear your opinion on the issue as an expert. So thank you.
Oh, well, let's calm down with the expert though, huh?
Yeah, I got a good question from someone Suri who says, it's my understanding that Minnesota considers all hemp as hemp and isn't distinguishing between Delta 8 and 9, for example. Is that the case? No, I think in the updates to the hemp-derived market that were made in HF 100, specifically said that there are limited amounts of quality controlled Delta 8 and Delta 9 that can be included in these products, but they really drew bright lines around other artificial and synthetic cannabinoids that can be derived from hemp, again, trying to create a consumer protection and testing kind of regime. So by the way, I will also say on the driving thing that I agree that this is an important topic. I also will say that that multi-year studies out of Colorado have shown that traffic DUI arrests and convictions remained relatively flat as they went through the process of legalizing cannabis, i.e. It was not a sudden influx of people driving impaired. I think there's some education that's needed around people making sure that they're not driving impaired, but I don't imagine that it's a rush of impaired drivers on the street all of a sudden. People have been using these products. It's just been illegal to do so.
There's a follow-up, our DRE trained officer being recognized as experts. I don't typically see them being like formally being requested to be deemed experts. Typically, I mean, but the bottom line is they're cops testifying. They're going to wear their uniforms, come in, they're looking the part of a cop, in which case then they're kind of treated as if they're experts and treated as if they can do no wrong and will never lie or never exaggerate. So I don't think there's necessity to get them deemed a quote unquote expert. And that's not been my experience in how they kind of treat them, which is testimony in general. But they sure act like state prosecutors do act like they are the kind of end all be all when it comes to their training and experience and what it shows.
All right, so I got a question. Any advice to residents of condos who suffer from the secondhand smoke from cannabis users? So interesting question. I mean, as a condo owner, I assume your neighbors are also condo owners, right? So we've got a clash of different kind of private property space interests here. And I think it's going to be a balance of trying to protect both needs. It's sometimes people will say, well, people should just, consume cannabis in non-smoking ways. I will say, I know medical cannabis users who say that smoking really gives them a lot more relief than other kinds of use. And so I agree, HVAC is important. People using outdoor areas is important, but in my opinion, restricting use so much that it's not really legal anywhere is putting us back in prohibition. So we need to figure out ways to balance. And then an even harder question, what, if any, opinion do you have on when marijuana likely will be legalized at the federal level? I wouldn't hold your breath. It's sad because fully 70% of Americans support legalization. But almost half of Americans live in states where there is adult use rec now. But with the current Congress and the kinds of legal changes that we would need to make to undo the war on drugs prohibitions, it's going to be some time. All right. Well, 12:51. Sarah, do you want to wrap us up, or do we have any final questions?
Yeah, if there are any more questions, please go ahead and put those into the chat. We'll keep an eye out for those for just another moment. Another thought did actually occur to me, though. Thinking about, employment and drug testing, how will these changes affect those kind of policies? Do you have any thoughts on that?
So we actually did a panel with an employment lawyer, Kate Bischoff, and I wish now that she was here because she was fantastic. Perhaps we could do a follow-up with her or so forth. Her, I think her primary takeaways were the ability of employers to test is greatly restricted by HF 100. In general, people should be able to use cannabis like alcohol, meaning they can use it on their own time in accordance with law, and they can't be impaired in the workplace, right? So the problem is that when you test for THC, you only know if someone has used THC within the last 30 days, which certainly could have been at home or whatever, right? And so instead we need to look for functional impairment at work in the same way that we sort of do on the driving, right? Are people showing up to work not ready to work? The PowerPoint it should be available to download. Someone asked in the chat if it was. Sarah, do you want to give advice about that?
Yes, the PowerPoint and the recording will be posted on the State Law Library's website, hopefully later today, if not certainly by the end of this week. So you'll be able to access those.
Terrific. All right, a question from Jeff. How have airports been dealing with different state drug laws and cannabis laws specifically? I don't know that I have a lot of insight on that, besides that, I would always caution people not to bring cannabis products, into an airport space. Then you more enter a federal space versus a state legal space. All right, well, thank you guys so much for attending this webinar. I hope that you found it helpful, thought-provoking. If you would like to follow up with James or me on anything, I've got our contact info on here. If you know folks that are looking to stand up businesses in the cannabis industry, I would love to be useful to them, and really appreciate your time and attention today.
Thanks, everyone. Hopefully you just know me and never need me as a criminal defense attorney, but appreciate your time today, and obviously do reach out with questions.
Thank you very much.
Thank you so much, everyone, for attending.